May 11th meeting of the Douglas County Criminal Justice Coordinating Council. My name is Pam Weegin. I'm the chair of the CJCC. I want to pass on a bit of information regarding how we will conduct our meeting on Zoom. We ask that all members please turn on video if you have it. We ask that all members and presenters use good conference call etiquette and mute their line when not speaking. We ask that you please identify yourself each time you speak. And if you have a public comment to make during the public comment section of the agenda, please use the raise your hand function on Zoom. A recording of this meeting will be available at the CJCC website after each meeting. The recording of the April 13th meeting can be found on the CJCC Hub. We wanted to welcome today the interim Lawrence Police Chief Hapley. I don't know if he actually made it in yet. This is
you know what? I don't think I gave him the individual invite, so he just emailed me and I'm sending that to him right now. So he'll be on in just a second, Pam. Yeah, let's go ahead and move on.
So our first agenda item is an update on the Indigent Defense Services work group. And Mike, I think you were going to talk about that.
Yeah, so several of you had asked, and I just wanted to make sure I provided a clarification on as you know, the Board of County Commissioners had a work session on Indigent Defense Services for Douglas County, and several of you were part of that work group. The Board of County Commissioners wanted some follow-up information, quite a bit of follow-up information from that work session, and so they appointed a work group to answer their questions and to provide more information and research. And so I just wanted to clarify a couple of things. And one is that it's not a work group of the CJCC. The CJCC's role is not to thumbs up or thumbs down a particular project like this. You know, our work is to facilitate research and put data together for the decision makers. And so while many of you are working on that work group, that is our goal, is to put together information for the Board of County Commissioners and for the district court to be able to make a collaborative, informed decision along providing this vital service. And I just wanted to highlight the people serving on this work group real quickly, if you don't mind, Pam. Commissioner Shannon Portillo is on this work group. From the district court, Judge Hanley and Judge Donovan have joined. County Administrator Sarah Polinsky, of course, Pam Weegin representing Criminal Justice Services, representing Kansas Holistic Defenders is Sam Allison Natalia, Reentry Director Carrie Nice, from Heartland Radak, Jason Hess, from the District Attorney's Office is Josh Seiden, from BIDS, Heather Cessna and Brandon Barrett, from our defense panel, Blake Glover, and then Matt Cravens and myself are helping to facilitate and provide data to the work group. So I just want to keep everyone aware of that. And as that work group develop recommendations or put data together for the commission, of course, we'll be sharing that with the commission. But I would like to forward that information on to you as well, as you are, you know, some of the key leadership in the criminal justice system. So. Any work group members want to jump in on that at all? Put you on the spot. So. All right, great.
Great, thank you, Mike. Our next two or three agenda items are going to be presented by Sheriff Jay Armbruster and Dr. Matt Cravens. First off is the question, if there are any questions about the sheriff's dashboard. Seeing none, I think we'll move on to the bond data that you're going to present today, Matt?
I just want to be clear, Pam, you're asking for just any follow-up information
Well,
that
if-
would have been presented at a previous meeting. Let's kind of use a,
Yeah,
make sure
sorry,
everybody understands what we're talking about.
sorry. Yeah, this is the follow-up from the last meeting when they presented the dashboard for the sheriff's office to see if we have any questions from anyone after that presentation. Not seeing any. I think our next agenda item is a presentation on bond data by Dr. Matt Cravens and Sheriff Armbruster.
Hi, everyone. Sheriff, did you want to say anything before I jump in, or should I just start?
No, go ahead. Thank you.
Great. Well, I'm going to share my screen. Hi, everyone. Just to give you a little bit of background, about 10 months ago, we presented some data analysis showing that members of some racial groups were being disproportionately booked into the Douglas County Correctional Facility relative to their population in the county, and that Black and Native American inmates were staying longer in the facility than white inmates for similar offenses. We've done a lot of work in the last 10 months to try to understand why that's happening. And one step of many in this process has been to determine if bond amounts ordered by judges are contributing to these racial disparities in bookings and length of stay. So this presentation presents the results of that analysis. To provide some background, in this analysis, we'll be describing municipal court cash-only bonds and district court cash and surety bonds. And so here are the definitions of these bonds. With a cash bond, the defendant pays the entire amount of a bond set by a judge. Once the bond is paid, the defendant is released from jail to await trial. The defendant gets the money back at the end of the case, and if the defendant fails to appear, the bond is forfeited. With a surety bond, a defendant contracts with a third party like a bond company to pay the amount of the bond set by a judge. The defendant typically pays about 10% or $150 minimum, and then the defendant does not get the money back at the end of the case. Once the bond is paid, the defendant is released from jail to await trial. Municipal court handles alleged violations of city ordinances within the city limits. Cases involve criminal trespass, driving under the influence, and other misdemeanors. In this presentation, municipal court will refer to the Lawrence, Baldwin City, and Eudora municipal courts. The criminal cases heard by district court can involve a range of offenses like battery, driving under the influence, murder, drug, and other crimes. It handles criminal and civil cases involving state law, and the criminal cases involve both felonies and misdemeanors. So hopefully that'll provide a little background as we get into the data. So this analysis summarizes data on the last 5 years of bonds. Specifically, we present data on bonds for all bookings into DCCF, or the Douglas County Correctional Facility, from 2016 to 2020. And here are the median cash bond amounts for municipal court bookings for each racial group. I leave off the Asian group because the sample size for that group is too small to make any meaningful conclusions about. So the figure shows that the total amount of cash bond order for a booking is $313 for white defendants. So this is the cash amount to be paid in order to be released from jail. So if a person has two $200 cash bonds in municipal court for different offenses at booking, the total will be $400 for that person. And again, the median amount for white defendants is $313. Note that the amounts for just 2020 are a little higher. I'll go over those in the conclusion. But these are the median amounts for the 5-year period that we're analyzing. Black defendants have about a $50 higher median cash bond amount than white defendants. Hispanic defendants are ordered to pay about $100 higher cash bond amount in municipal court than white defendants. And note that throughout this analysis, we'll be counting people as Hispanic only if their race is recorded as white. The small number of Black and Native American defendants who also report being Hispanic are classified as Black or Native American. And there are a few reasons why Hispanic defendants could be getting higher bond amounts that we'll mention in slide 6. So these are the median cash or surety bond amounts ordered for district court bookings. These are the raw or unadjusted bond amounts. In other slides, we'll show the amounts controlling for other factors. And just a reminder that the median is the middle value in a sample. So half of the values are lower and half are higher. Black defendants are being ordered to pay about $500 higher cash bond amounts than white defendants by district court. That translates to about a $50 out-of-pocket difference for people posting surety bonds. Recall that with surety bonds, a defendant can pay about 10% of the amount to a bond company to be released. Hispanic defendants are ordered to pay $500 lower bond amounts, lower median bond amounts than white defendants. And Native American defendants have the same median bond amount as white defendants. As a next step, what we can do is control for characteristics of the defendants, their offenses and cases. And so what we want to do is see if these differences remain after accounting for any differences in the case or offense characteristics across racial groups. For example, if arrestees of one racial group tend to be arrested with more offenses, we can look at bond amounts treating all arrestees as having the same number of offenses. Before I move on, any questions? Okay. So here's information about the data and method. So we use data on bonds set for all bookings from 2016 to 2020. The data are from the Spillman Jail Management System. We'll use multivariate linear regression to carry out the statistical control described in the last slide. I'll be referring to regression adjusted numbers in the next slides. A regression adjusted number is the number after controlling for other variables in a regression model. Most of these variables were selected because they are variables that judges consider when setting bond, other than gender and age. Specifically, in the following figures, we're adjusting the bond amounts for gender, number of offenses at booking, and note that all offense information is at the point of booking. It's not information about what people are actually charged with by prosecutors, which can be slightly different. Number of DCCF bookings over the years, which is similar to criminal history. It's different because it's only for Douglas County Correctional Facility bookings, and it leaves out bookings in other jurisdictions. But we find that it's a reasonable proxy for criminal history. Case type, for example, traffic, criminal, or other case. Offense type, probation violation or assault, for example. There are a large number of case types that we control for. Felony, misdemeanor, unknown classification, and judicial status, for example, if someone's pretrial or not. Now, as I mentioned, most of these variables are ones that judges consider when setting bond, but judges also have other information at their disposal, like more detailed criminal history information, offense severity information, and information about charges rather than offenses at booking. So here is the average cash-only bond amount in municipal court after adjusting for the factors that we discussed. You can think of these as the average amounts that defendants from each racial group would have to pay if everyone had the same offense, demographic, and case characteristics. It seems that similarly situated people from different racial groups are not being assigned different bond amounts besides one group. The difference between the Hispanic and white amount is statistically significant. Hispanic defendants are ordered to pay about $76 more in cash bond than white defendants, holding all of their variables constant. So we have a few guesses about why Hispanic defendants could be getting higher bond amounts. Hispanic defendants do have more DUIs. 23% of bookings for Hispanic arrestees have a DUI compared to only 16% for white arrestees. And DUIs are a bigger public safety concern than other offenses. Also, nearly all or 98% of cash bonds ordered in municipal court are for failing to appear to court for FTAs. And the data suggests that Hispanic defendants have more FTAs for DUIs. So bond could be set higher for Hispanic defendants out of public safety reasons specific to DUIs. One solution to this disparity might just be to reduce the fees associated with DUIs. Those fees can be quite high in Douglas County. Second, Hispanic defendants in municipal court post their bond more quickly than other groups, as we'll see on average later in the presentation. More Hispanic defendants may be posting bond prior to when bond reduction hearings usually occur, so they won't tend to get the benefit of those bond reductions. So Hispanic defendants are paying bond a little earlier and at somewhat higher amounts. Also, for some types of FTAs in municipal court, cash bond amounts are set to the amount of court-ordered fees and fines to be owed if the person is convicted. So a warrant could be issued in this case. If Hispanic defendants tend to commit offenses that carry larger fines and fees, then that could also explain their higher bond amounts. So these are just educated guesses based on the data. We will do more research to try to understand this disparity, I'll pull the data on all Hispanic defendants with municipal court cases with cash bond for Judge Miller, and we will look at those in the near future.
Dr. Cravens, this is Commissioner Portillo. I appreciate that we're going to have additional research on these areas. I just wanted to clarify, for this particular graph, you are controlling for offense type. And so how would the DUI versus non-DUI piece come about, since
That's a
offense
very
type
good-
is being held steady?
That's a very good question. The one thing we cannot control for is the underlying offense of the FTA. So I control for failure to appears, but I don't control for whether or not that FTA was for a DUI hearing or something else. And my guess, based on the data, I don't have systematic data, unfortunately, from Spillman on what all the underlying offenses are, but based on offense analysis, the data seem to suggest that Hispanic defendants have more FTAs for DUI. So I hope that answers your questions. We control for FTAs, but not the underlying offense that the FTA is originating from.
But we're going to be going through all of the cases individually to actually take a look to see if that holds up.
Yeah, I mean, there's going to be a lot of sort of hand looking up of things, and unfortunately, the Spillman system with the offense information is linked to the court system, the full court data system that has the underlying offense for the FTA. So, but we can look them up manually, and we'll do that here in the coming weeks.
Great, thank you.
I had a question, Matt.
Yeah.
On that sample that you're using, are you using median for both, or did you switch to mean at one of them?
Yeah, I switched to mean. What I did actually is I took the log. I didn't mention this before, but I took the log of the cash bond amount and modeled that because it allows for better statistical properties of regression modeling. And then I took and then the results here are presenting the average of the log, and then I unlogged it for the presentation purposes so people could see the amounts. So to make a long story short, I use statistical best practices to sort of get at a good average amount that's not skewed by outliers. So although this isn't the median amount, it's sort of been adjusted so that it's not skewed by outliers. Does that help answer the question?
No, I guess my question then is, why are we using for the first graph 1, and then we are adjusting, you're doing the regression adjusted average, but it's using a different number?
Yeah, I mean, the reason is just if I did, so you can't model the medians. There in regression, you can't, the sort of coefficients or the effects of a variable. What I'm trying to do is determine the effect of being Hispanic or the effect of being white or Black or Native American. You can't, those effects can't be determined as medians. You can only interpret those as averages. And so because of this sort of the skewed distribution of the data, because there's, most people have sort of lower bond amounts, and there's a few people with very high bond amounts. What it helps to do is, instead of taking the median, because we can't report the median with regression results, we log the dependent variable or the outcome variable, which is the bond amount, and then report on the average of the log. And I know that sounds a little complicated, but it's just, it's the way around it, because with regression, you can't report median effect sizes.
This is Commissioner Portillo, and what I would say that we're really looking at when we're looking at OLS results is what differences are significant or not. And so really what we're seeing here is that being Hispanic in our system means that there are significantly different outcomes for folks than other racial or ethnic backgrounds, not necessarily exactly what that difference is.
That's a great way of saying it. Yeah, we're essentially trying to do sort of an experiment, and we can't randomly assign people to different racial groups, but we can sort of statistically say, all right, what is the effect of being Hispanic holding constant all these other things? So if we kind of assume that everyone has the same gender, age, offense type, judicial status, and felony misdemeanor status, assuming everyone has that same set of characteristics, here's the amount of bond that would be set for these people. And the statistical significance tells if one group is different than the other in a way, sort of like an experiment, but different.
Matt, this is Judge Miller. If I understand your control correctly, the way you explained it, and I didn't understand that when you were explaining things originally. So when you're doing the control, you're controlling for a failure to appear on a speeding ticket and a failure to appear on a DUI the same way because you can't tell what the underlying charge is.
Exactly, yeah.
How do we get the data we need to run appropriate analysis on that? Do we do it by
Yeah,
the charge? Do we break it down by individual charges? For example, DUI charges, traffic charges, something like that? Or how do we get the data set we need to make a better comparison?
Yeah, what we need to do is look up every single FTA or person with an FTA and look them up in full court to see what the underlying offense is, and then sort of attach that data onto the data set that I currently have. So, so if someone has an FTA in Spillman, I'll look it up and then it says, okay, they failed to appear for a DUI hearing, then I'll mark it down as FTA for DUI. And then we'll go through each one of those cases. It'll be a lot. We'll probably start with just 2020. And then sort of get that information for each of the FTAs and then try to model that separately to get a more accurate view.
And then when we do that information pool, do we need to pull original bond amounts in order to do comparison?
Now we could do that. That's something that's sort of worth discussing more because what Judge Miller is referring to is the fact that these bond amounts are sort of the final bond amounts at release. A person can be assigned a certain bond amount at booking and then it can kind of be changed a little bit. And then this is the final bond amount that's listed in the system. So the question about whether or not we can get original bond amounts, I believe that information can be gleaned from full court, but whether we want to do that is another issue. So we can think about that. If you think that's useful, maybe we can look into that.
And I guess the last question I had is when you report someone who gets released without having to post bond at all, when they're just released by the court, how's that reported in your analysis?
Yeah, if they have a bond listed, then that bond will be, in the data set as whatever the bond amount is. Eventually if it's cleared by time served, like if the bond was sort of cleared by them actually just serving their time, it'll be marked as cleared by time served. But whatever bond amount the judge assigned for that person will still be listed in the system for that person. Does that answer your question?
Well, for example, the court, as a matter of practice, a lot of times will just release people. We won't set an OR bond after a hearing. We'll just release someone, give them a new court date. How would that be reported in your data set?
Whatever the bond amount that was listed for the person prior to them being released.
Okay, thank you.
Yeah, Judge McCabe.
Just as a preemptive comment, and I appreciate Judge Miller's questions. I appreciate Commissioner Portillo's question about reviewing individual cases. That really is going to be the only way, in my mind, that we can have a valid data set to reach conclusions if the purpose is to analyze the decision-making processes of the judges. What these numbers are reflecting is some correlation between booking information and, I guess, bonds at the time of release, but that is not an answer to the question of what bond did the judge set at the beginning of the person coming into custody, and did that influence how long that person stayed in custody? It's two different data sets that have to be analyzed, and I think Judge Miller's questions highlighted the areas that I was going to comment on for the district court. So as we go forward, I just want people to have that in mind.
Great, thank you very much. And as with any data analysis, there are limitations of certain things, and it's great that we're pointing these out. There's no sort of quote unquote perfect data set. Getting a better data set that answers the questions about judges will be useful. So hopefully that'll happen in the near future. So the sample of district court cash only bonds and municipal court cash surety bonds are not large enough to make any statistically meaningful conclusions about. For example, municipal court only accounts for 1% of cash or surety bonds, so we're not going to be analyzing them here. So this is the regression adjusted average district court cash or surety bond amount per booking. And there don't appear to be any large differences between the racial groups in average cash or surety bond amount in district court after controlling for the types of variables that judges tend to consider. Black defendants are ordered to pay about $133 more in cash or surety bonds. That only works out to be about $13 in out-of-pocket payments to a bondsman if they post a surety bond. So that's relatively modest. We've been looking at this data carefully, and we kind of suspect that if we could control for every possible variable, including detailed criminal history and offense severity, the difference between the white and the black amount would shrink further. We'll talk more about what the control variables are doing in the next slide, though. Hispanic defendants are ordered to pay lower bond amounts than white defendants, but that difference is not statistically significant. So I want to show what the control variables are doing to the results and why I think the results may be evidence of systemic racism rather than any sort of individual racism by court actors or judges or anything like that. So this shows the average district court cash or surety bond amount after controlling for variables in different stages. Without the controls, the racial disparity between black and white defendants is clear. Black defendants have higher bond amounts and Hispanic defendants have lower bond amounts. After controlling for case type, the black-white disparity declines some. Black defendants are somewhat more likely to have criminal cases than a traffic case in district court. Hispanic defendants are more likely to have traffic cases. After controlling for gender, age, felony, misdemeanor classification, and judicial status, the disparity declines more. And after controlling for the number of offenses at booking and number of DCCF bookings over the years, the black-white difference declines more. So what this last point means is that black defendants tend to have a slightly higher number of bookings over the years, at least in district court, which is a proxy for criminal history. And they're booked into DCCF with a slightly higher number of offenses. They're also more likely to have a criminal case rather than a traffic or other case. And when you control for these and other variables, black defendants are getting similar bond amounts as similarly situated white defendants. But if you don't control for them, the black-white difference might be about $50 higher. So that's just what I'm saying by controlling for certain variables like number of bookings over the years may underestimate racial disparities by slight amounts. So the fact that the system considers criminal history when setting bond may be evidence of some systemic racism. Studies show that black citizens are more likely to be arrested and booked into jail. In Douglas County, black citizens are arrested at 3 times the rate of white citizens relative to their size of the population. So they gather somewhat more criminal history and can be subject to higher bond amounts, even if their actual propensity to commit new crimes is not necessarily higher. So yes, I see a question, Judge McCabe.
So it may be just so that the council understands the terms of art. When Dr. Cravens says number of bookings at DCCF is a reasonable proxy for criminal history, those bookings do not correlate to criminal history as the district court uses that term. We do look at, and frankly, more so in the last 2 or 3 years because of pretrial and the reports that they're generating, we are more cognizant of criminal history score as that term is defined under Kansas law. And we are looking at the actual charges filed. And those are the 2 biggest drivers in making a bond decision. So just to help the council understand, when a judge is making a bond decision, I think it's fair to say that the 2 things you're going to want to give the most weight to are what's the crime charged? Is it a level 10 felony? Felonies in Kansas are ranked 1 through 10. 1 is the highest, 10 is the lowest. There's off grids that don't matter for this discussion. If you're charged with a level 10 theft felony and you don't have any criminal history, the odds that you are going to get an OR bond in this district approach 100%. It would be my wager. If you're charged with a level 1 felony, a murder, whether you have a criminal history or not, your bond is likely to be somewhere between $250,000 and $500,000. Then if the judge knows about criminal history, those are going to be sort of aggravating factors for adjusting the bond upwards in most cases. And our pretrial reports may give us other information that help offset some of that. But so when you hear the term criminal history being used for purposes of this analysis, that is a different term than what the district court is relying on. And when we have the gray bars that say controls for offense type, the distinction is limited to misdemeanor or felony. And within felony, there's just a very broad range of severity levels that can influence. I think Dr. Cravens told me yesterday, things like murder were not included here. But again, just definition purpose, offense type is totally different, has a different meaning in how the judges use it than what's being presented here. And I just want the council to be aware of what we're looking at.
Thank you very much for that clarification. And the offense type variables are different than the felony misdemeanor classification. The felony misdemeanor classification is in the orange bar. The offense type one, you may have been saying this, I'm not sure if I misunderstood you, but the offense type one is when we control for drug or assault or battery or domestic violence, et cetera. But you're right, there's a lot of variation within each of those offense types. And thank you. DA Valdez.
So I was just going to chime in. I agree with what Judge McCabery said in terms of clarification from the DA's perspective. We do look at criminal history. We do look at the charges. In particular, we're very cognizant of charges involving firearms because those are dangerous offenses, especially something that could be what we would say if you strip out the firearm would be a battery. You have a firearm, it goes south fairly quickly. So that's something that's of very high concern for the office. And then we look at victimization. Certainly, if we've got a vulnerable victim, a child age victim, those are considerations as well. So I just wanted to let you know there's some presumptive bond amounts that are in play, if you will, based on the severity level of the crime as it's charged. But there are some variables there that based on what we're seeing in terms of trends, and certainly firearms is a big, I believe, a problem here that we're really trying we do take very seriously. And so those are considerations when we make our bond requests. Those points are made to the judges as well.
Great.
And if I can just add, the only reason for these comments are to make the rest of the council aware of the limitations of how to interpret the data that's being presented. So.
Great. No, thank you for these inputs. This helps. So this table shows the time to clear for cash and cash surety bonds. The time to clear is the number of days between when the bond was issued and when it was cleared. It could be cleared due to bond being posted or due to release on the judge's authority, or if the person finished serving their time, or if the charge is dismissed or some other method. The table shows the median and mean days to clear. Again, the median is the middle value in the sample. Half of values are higher and half are low. The mean is the average. The mean here is 0 to 1 days for all groups, which means that most bonds clear relatively quickly. Black defendants, municipal court bonds appear to clear faster than white defendants, but for district court bonds, the median and mean days to clear is higher for Black defendants than white defendants. Native American defendants' time to clear is higher in both municipal and district court. Native American defendants take 3 to 4 days longer for their cash and cash surety bonds to clear than white defendants' cash and cash surety bonds on average. And the time to clear has been growing in recent years for Native American defendants. If I use just the data from 2017 onwards, the median time to clear for district court bonds was 2 days for Native American defendants. And this might help explain why Native American pretrial inmates are staying a little longer, or staying about 3 days longer on average in DCCF. Hispanic defendants bonds clear faster than white defendants bonds. We mentioned that before in the context of municipal court. So even though bond amounts are about the same for white and Native American defendants, they take longer to clear for Native American defendants who appear to have a harder time affording bond. The data also indicate that Black defendants' district court bonds take longer to clear. So courts already consider individuals' ability to pay, but it's worth asking from these results whether courts could consider it more when setting bond, and it's probably worth doing more research on how ability to pay affects people's time in DCCF too. Any questions on this? So this shows the average days in DCCF for people staying pretrial. Black and Native American pretrial inmates stay about 3 days longer than white pretrial inmates on average. Using the median values instead of the means reveals even more exaggerated racial disparities, in fact, but the median values are lower overall because about half of arrestees stay less than a day. These disparities are primarily driven by district court. For municipal court only bookings, there's only a disparity for Native American defendants, and it's smaller than what we see in this figure. The fact that Black defendants have higher bond amounts in district court in the raw data may be contributing to their longer length of stay pretrial. I'll recall that Black defendants had about a $500 higher raw cash bond amount. Of course, the variables we discussed can help explain why the Black group has higher bond amounts, and those variables can also help explain some of their longer pretrial length of stay as well. So this figure shows that as bond amounts grow, people's length of stay in DCCF pretrial grows too. Municipal court bookings are on the left and district court bookings are on the right. So here are some conclusions we can derive from this analysis. So people with higher bonds tend to stay longer in DCCF. The median municipal court cash only bond amount per booking in 2020 is $363. The mean is $631. The median district court cash surety bond amount per booking in 2020 is $2,000. The mean is $8,615. And just remember that with cash only bonds, you pay the full amount. You can't just pay the 10% to a bondsman, but you do get the money back if you show up to court. And these are the amounts in 2020, which is why they're slightly higher than the amounts shown in prior slides. And this can be a lot of money for defendants, and if they can't afford to pay it and aren't in the pretrial release program, they do stay in DCCF. And studies show that staying in jail pretrial is associated with negative outcomes like an increased likelihood of being convicted, receiving a more serious sentence, and losing a job and housing, among other outcomes. It should be noted, though, that the judges can and do work with defendants. Sometimes judges will release people or amend bond amounts if the defendant says they're in jail because they can't make bond. One caveat to this is, of course, that these steps typically occur after someone's already been in jail for a number of days, but it is something that judges routinely do is amend bond amounts. And we should remember that judges set high bond to prevent people from being released for public safety reasons, and they also set bond high with the intention of reducing the risk of flight and motivating court appearances. I hope to do a literature review on these effects at some point in the future, and whether or not these hold in actual jurisdictions. Regarding racial disparities in municipal court cash bond, we initially found a disparity in the raw data before controlling for other variables. Hispanic defendants have higher median cash-only bond amounts in municipal court. After controlling for various demographic case and offense characteristics, we find a $76 statistically significant difference between Hispanic and white defendants. Some of the reasons we discussed earlier may be causing this. Regarding district court cash or surety bonds, Black defendants have $500 higher median bond amounts. After controlling for other variables, the differences between the racial groups are smaller. And when you calculate the out-of-pocket difference someone would pay to a bond company, the differences are modest, about $13. Here's some caveats. Certain control variables may be influenced by race, like the number of bookings over the years. Again, this isn't a perfect proxy by any means for criminal history, but it is a proxy that we're using here for criminal history. Using these control variables may underestimate racial disparities or racial differences in bond amounts. Judges consider many of these variables when setting bond. Also, even equal bond amounts can result in inequitable outcomes if some groups tend to be poor and less able to afford the same. And just on the previous point, I'll say we've already sort of discussed some of the issues with using criminal history. It can be sort of a non-objective variable just because we have found in some data sets that persons of color are more likely to be arrested and booked into DCF. So there is sort of a widespread influence of or there appears to be an influence of race on criminal history. So even if, as I said, even roughly equal bond amounts can produce inequitable outcomes, and we should consider individuals' ability to pay when setting bail as much as possible. We also found that it takes longer for Native American defendants' cash and cash surety bonds to clear, and Black defendants' bonds in district court take longer to clear. This could be because those groups tend to have a harder time affording bond, and this might be a reason for Native American and Black defendants' longer stays in DCCF pretrial. We did see that Native American and Black pretrial inmates are staying about 3 days longer than white pretrial inmates on average. All in all, the data reveal how systemic racism impacts the criminal justice system. Race appears to be related to the frequency of contacts with the system, criminal history, and types and number of charges. These variables drive decision-making throughout the system. We'll continue to analyze other decision points besides bond assignment to explore why people of color are booked into jail at disproportionately high rates and stay longer than similar white inmates. And we will delve into this data more by looking up the FTAs, for example, and looking at full court data to see specific information about charges as well as offenses at booking. So thank you very much. I'm open to any questions you might have. Pam.
Matt, this has been an incredible presentation. Clearly, we need to do some drill down in some of that data. I did have a question. I don't see anything about unrecognizance bonds. Do we have any information on historically what's happening with OR bonds?
Yeah, we do. In fact, we have a prototype of a bond dashboard that lists unrecognizance bonds amounts. And for other people's knowledge, this is the amount that people would have to pay if they don't show up to court, but they can just use their signature to be released from jail at the time that they're booked in. But we have done a limited amount of analysis of that, but not too much and nothing presented here.
Thank you.
Yeah, Marielle.
First, thank you for this presentation. I think it kind of affirms and confirms a lot of information that I had already suspected was true regarding racial disparity in our criminal justice system. But I guess I don't know if this is a question or more of a, I've been thinking of the past two meetings and about our data collection and how we categorize folks. And I'm just really thinking about this white, Hispanic, white, non-Hispanic group, and if it's truly helpful data, because Hispanic and Latinx is an ethnicity and not a race. And so I feel like there's just this like confusion of data, and is this truly helpful? Are we missing an entire group of individuals when we start conflating these two identities of ethnicity and of race? Because you can be Latinx or Hispanic and be white, and that's what's being documented here. And so is it true? I guess it's not a question, it's more of a comment, is this truly helpful data in that, or are we missing a piece here? And how do we, I guess, sit with that I think it's so important, especially thinking about folks who are undocumented or in mixed status families. Where is their information in this? Because I think that they're, especially with bonds and the inequities in posting bond, setting bond, and things, is that's a very important piece. And I don't know, I'm thinking about it and sitting with it. And I think it just kind of, I'm trying to understand this data better, and also calling back to our last meeting where we did have that discussion, and also understanding that how we pull this data. But I just think it needs to be, I don't know if there is a better way, or if I need to just be more oriented towards where those individuals are, because they're not Native American, they are Native and Indigenous, but not particular to this country, but they're also not white or non-white. And so is it really beneficial to have that category broken down for white folks to be Hispanic and non-Hispanic, when it might not be addressing the racial identities and what we're specifically talking about here? So I guess I want to know if you have any like comments or feedback on that. I'm definitely open to hearing it.
Yeah, and it's really important to define these categories accurately because they are people's identities, and glossing over certain things by talking about it as race instead of ethnicity is not a good idea, and it's important to bring up these kind of questions. I will say, I hope this is consolation. I also did the analysis treating everyone who responded as being Hispanic, even the small number of people who reported being Black and Hispanic and Native American Hispanic, in a separate variable for Hispanic, and the results are very similar. So, for the analysis that I presented here, I had to define Hispanic some way, and because people both are required to fill out a race variable and an ethnicity variable in the data set, I recorded people who are white and Hispanic as Hispanic, and then people who are Black and Hispanic I left as Black, and people who are Native American and Hispanic I left as Native American. But if I did the analysis with just one Hispanic category for everyone, regardless of race, the results turn out very similarly. So, I didn't want to sort of present data in two different ways, but I'm happy to sort of go over that later with you at some point if you'd like.
Yeah, that's helpful. Thank you. And I think it's just kind of, it opens up that bigger conversation that I think that particular ethnic identity is still unpacking, and those nuances and differences I think are very important, especially when we're talking about criminal justice, because there is racial difference when it comes to folks who do identify as Hispanic, but do racially fit into the category of white and what privileges and access they have versus other racial groups that also have that Hispanic identity. And so I think it's, thank you for giving me more of that feedback. And I would definitely be interested in kind of breaking that down further.
This is Commissioner Portillo. Marielle, I think that your question is incredibly important. I also struggle with the kind of either or framing of, is it helpful or is it not? Because I think that data can be flawed and helpful. So we know that we need better categories. We know that we need a better understanding of not just categorization, but the really important history of how we've gotten to these types of racial and ethnic categories within our country. And you bring up a really important point of not just the racial and ethnic categories, but also layering on top of that immigration status, and how status and being from a mixed status family can affect all of these things in even more complex ways. So I think we can learn a lot from the data that are presented and the data that we have, and recognize that we need better data and a better understanding of where these particular categories come from and how they affect our community and the history of that. So I really appreciate you reminding us all to think through that history.
Yeah, absolutely. And I think it just, sometimes those nuances, and especially talking about criminal justice and thinking of how the community responds to this kind of data, is not that you want to see yourself reflected in criminal justice data, especially when it comes to bonds, but it helps people orient when they can understand how their identity fits within this. And so that's where I'm thinking those nuances are incredibly important. And I do agree with Commissioner Portillo that this data is important, and how we see where we're at now, but also those nuances really help support how we help those specific communities navigate this system and what issues we're seeing with those specific groups, because it is very, it is different. And it's hard when we create these larger categories, and especially since, racial and ethnic identity and how intertwined they are is definitely a symptom of systematic oppression, and can be really complex. So I think it's important to speak that in this space, and also just know that we have this data, and how we use it going forward and how we help the community understand this data is super important.
And Marielle, to your point, I feel like I've got to kind of out myself as in my own personal journey through all this, and the fact that I didn't even understand the information that as a law enforcement officer, as a jail person working in the jail, how important the information was. But I had to reach out to Commissioner Portillo to really help me dive down to understand the difference between the race and ethnicity of the Latinx and all the different categories and all that stuff. So it's been a journey, but I suppose in the overarching look at it is that I feel like where we're at today is with the drop down, cookie cutter boxes that we've only been allowed to fill out. But moving forward, the state may require these certain questions, but we as an agency can broaden our questions to be more inclusive and ask, to get more accurate data. So if that's something that we as a facility need to broaden our data to ask for further questions, about, how somebody identifies or what their race or ethnicity is. And that way we can get a fair and accurate representation. We're more than happy to try and do that. But yeah, I think for now unfortunately we're stuck with some numbers that we didn't realize were going to become so important.
Yeah. And yeah, I think it's all about this is something that moves and changes, and how we move and change with that is very important. And I think if we can be more, yes, we have this structure that's been given to us, but we also want to start defining those nuances, especially for, I think of community organizations who are oriented around helping around racial justice, and them needing that information to help support the community and help support. I think of, not to center, but I think of Sanctuary Alliance, and that we need those numbers. We need to know how folks are identifying both ethnically and racially, and also, citizenship status is something else that's really big in that work. But having those numbers and them being more nuanced helps us. One, helps the community, like with the conversation, then also when we bring it to these spaces, when we talk with the sheriff or the DA about, trying to implement new policies and practices to support that community. It's really good that we have the most in-depth data we can, so we're not making generalizations and then really not supporting the community in the way it needs. So I think moving forward, knowing what we do have and knowing where we're at, and then how we can move forward is really important. So thank you for saying that, Sheriff.
Do we have any more comments or questions for Matt or the sheriff? I think the next agenda item, they're introducing a new
Sorry.
dashboard. I'm sorry.
Did Judge Miller have a question?
Couldn't see it.
I did, but it's fine. I just wanted to make a general comment that when I got the initial draft of this data, specifically regarding the disparities that were identified, I was substantially shocked, because a lot of our bonds are procedurally generated initially, because we don't have information on people who fail to appear regarding criminal history and things like that on a regular basis. So bonds tend to be issued, at least initially, for failures to appear without regard to any demographic characteristic. So I'm very interested in finding out why the disparity exists, and trying to make certain that we patch the system so it doesn't. I just thought I'd throw that in.
Thank you. Our next agenda item, you're going to introduce a new dashboard, I believe.
Yeah, Matt, do you want to go ahead and pull up the bond data dashboard?
I will.
And Sheriff, I don't know if you want to say anything as he pulls this up or not, or.
I mean, again, Matt will do the heavy lifting once again. I'll just sit here and look pretty. But all of these things, this really hard work has been done in order for transparency. We're trying to open the doors to have these fantastic conversations that we're having now to really take a deep dive and having everybody at the table. So I know that they may point in directions that we didn't expect, but I really appreciate everybody's really willingness to look at this objectively, and so I'll be quiet now. But
And I just want to say a quick thanks to Bryce Hirschman and the GIS team for teaching me and managing the software. And as with other dashboards, this is something we can amend over time. So this is the first version of it, and certainly changes can be made. So without further ado, here's our bond dashboard. There are notes in the left-hand column. And what it says here on the bottom is that the data are from 2017 to 2021 up until yesterday. The last update date says when the data were last refreshed. And the data only describe bonds issued by Douglas County District Court and municipal courts. So it does not describe bonds associated with out-of-county warrants. And again, municipal court includes Lawrence, Baltimore City, and Eudora municipal courts. The bond amounts for a defendant can change from the point of booking to release, as we've discussed during the presentation. And this dashboard displays the latest data in the system at the point of release. So over here, for instance, we can see the median municipal court cash only bond amount per booking by race and ethnicity. And this is similar to what we saw in the presentation. There is 481 for Hispanics, 383 for Black defendants, and 313 for white defendants. And then over here, we see the median municipal court cash only bond amount by year. And again, you can click on the top right-hand corner to expand or collapse any window. And this is best viewed on a computer rather than a cell phone. With a cell phone, you can still expand and collapse the windows, and that helps, but it's just squished a lot more. So what we see here is that the amount for cash only bonds in municipal court has risen slightly over the last few years. It's 363 in 2020, and it's about 313 in the current calendar year. This is the median district court cash surety bond amount per booking by race and ethnicity. The Black defendant amount is 2,000. The Hispanic amount is 1,000. The white amount is 1,500. The Asian and Native American amounts are 1,500. The median district court cash surety amount by year has increased somewhat over the years. It's now about $2,000. And what we're going to do is link to the presentation done today at some point on this dashboard so that people can see sort of what the analysis may look like with some statistical controls. Now, this is the median own recognizance bond amount per booking. Pam asked about this. There's a note over here on the side that own recognizance bond amounts are not required to be paid for release. The amounts are required to be paid if the defendant does not appear in court. So it's 1,000 for Black defendants, 900 for white defendants, 750 for Asian defendants, 950 for Native American defendants, and 750 for Hispanic defendants. And then we can see the amount over the years has increased slightly from about 750 in 2017 and 18 to 1,000 in 2019, 20, and 21. So over here in the top right-hand corner, we see the bond type. Now, this is something we didn't analyze in the presentation today, but it's useful to see the distribution of the bond types that people have when they're booked into jail. So this is data for 2017 to 21. We see that in that time period, there were 4,322 cash bonds issued, 6,086 cash or surety bonds issued, 7,244 no bond issued, and then 7,537 own recognizance bonds. The own bond amounts, sorry, the no bond category can include many revocations of probation and remands. And actually what you can do is click through, because that data is presented for 2017, 18, 19, 20, 21, and the distributions changed slightly, and also separately from municipal court. As we see here, there aren't hardly any cash or surety bonds issued by municipal court. And these are the number of cash, no bond, and own recognizance bonds. And then for district court separately, we see there's no cash bonds hardly, but there are cash surety bonds, no bonds, and own recognizance bonds. And over here on the bottom right-hand corner is the final panel. This shows the distribution of bond type for different groups. We have female defendants here, and this shows the last full year of data. So this is 2020 female defendants. 37% of their bonds are own, or 37% of bookings have an own recognizance bond. 13% have a cash bond. 18% have a cash surety bond, and there's no bond issued for 32% of bookings. For males, it's slightly different. There's a smaller own recognizance percentage. We see some differences between white and black defendants. Black defendants had own recognizance bonds at a lower rate and cash surety bonds at a higher rate. Hispanic defendants had own recognizance bonds at a lower rate than that, and cash and surety bonds at a higher rate. And there are some differences for Native American defendants, but their distribution is more similar to white defendants. So people can kind of go through that at their leisure, and we are open to any changes that people may have with that. So thank you for letting us show that to you, and any questions I can answer, just jump right in.
Matt, the median own recognizance bond amount per booking, so that last graph that's there on the left, on the bottom, does that combine municipal court and district court? Is that what I heard you say?
I'll have to double check. Yes, I believe that's for district court and municipal court combined, but that's something that I can sort of double check. And actually, I'll make a note of that on the left-hand corner or the left-hand notes box, because that is an important thing to note. Thanks. Yeah, Darren.
So Matt, Matt, this question may not be so much to you as to perhaps the judges. Y'all know me and my off-the-wall questions. I'm sort of, I'm sort of wondering, how do I express this? With bonds, whether it's cash, whether it's open recognizance, you know, I'm trying to, obviously there are differences that are happening based on various constituencies, identities, race, gender. I guess what I'm trying to wrap my mind around or wonder, is there a target of what this distribution should look like? Like, is there a clearinghouse of municipal and district courts that says like, that these percentages should look a certain way? Because I guess I appreciate the dashboard and it's clearly a lot of work. I'm trying to wrap my mind around like, where does this stand with how we think our judicial system here should be functioning? Does that question make sense?
I guess I've been operating under the assumption that they should reflect the general population, the numbers in the general population.
So sure, I think, yes, I get on board with that. But I'm wondering too, in addition to the sort of the racial breakdown and those relationships, like just even how much should we be, how much of it should we expect to be own recognizance? Because that tells me like how far off we are in a given subset of the data. Does that? So I'm co-signing what you say and sort of wondering if there's an expectation about what that breakdown should be within one of those groups.
I can try to answer. I don't think that there's a specific expectation other than fundamental fairness. The whole idea is that similarly situated people before the court get treated similarly without regard to things like race. I can tell you from the perspective of municipal court, you ask about how many OR bonds are issued. On initial arrest, it's virtually 100%, because everyone, when they're coming to court initially, with one very minor exception that I'll describe, they're granted either release on a signature or on a notice to appear and given a court date, or they're granted an OR bond after their arrest. The one exception is if somebody's getting arrested over and over again and they're getting arrested before they're arraigned on prior cases when they're granted an OR bond, then at that point they'll be held pending a hearing to find out what's going on and how to set an appropriate bond. Now, beyond that, in regards to OR bond percentages after they've already failed to appear, just from municipal court's perspective, and by municipal court, I'm talking about Lawrence Municipal Court. I know that there's some data in there from Baldwin and Eudora. Frankly, I don't think they have enough cases to influence the data one way or another. So, trying to lump them together with the municipal court numbers here is probably not fair to either of those courts. But, once somebody's already been granted an OR bond and forfeited that bond, the likelihood is they're not going to get another OR bond unless they have a really excellent explanation for why they missed the court date. So in that case, the target's not going to be very high. That's for municipal court cases. The cases that we deal with are very different in some respect to what the district court deals with. You wouldn't expect someone charged with a felony to automatically be released without seeing a judge. So I don't think you can set metrics like that and say there's a target here or a target there. Certainly you can set goals regarding things like bond amounts. If you find out bond amounts are generally unfair, or bond types or things like that. But I don't know that you can set a generalized set of goals for bond types. I don't think you can set an OR bond goal or a surety bond goal or a cash bond goal. Does that answer your question?
Yes, it does. It definitely gives me some things to think about, for sure.
And I'll say just quickly, Darren, that I think part of the goal of the statistical analysis with the controls was to sort of get at what bond amounts should be. And again, no data set is perfect, and there are obviously caveats about the offense characteristics and other things in the data, but that was trying to get at sort of, if you look at similarly situated individuals, like people with similar offenses, people with similar number of bookings over the years, people with similar number of assault and drug charges, et cetera, like what would their bonds be? And so we're seeing if there were any differences that arose after holding all those things constant. And we saw a few that were presented in the presentation, pretty minimal for district court, and ones that are somewhat explainable perhaps for municipal court, but that was sort of the goal of that analysis too. Yeah, Judge McCabe.
Professor Kennedy, I just want to reiterate, as far as drawing conclusions, because your question was, what should we expect from our judicial branch in how we arrive at these bonds? The data underlying these conclusions is materially different in my mind than the information that the judges use to make those decisions. So whatever conclusions we can draw from booking information and the definitions that Dr. Cravens came up with for the terms that he's using to explain the data. And I'm not trying to be defensive. I just want to explain there are two different data sets, and we've offered to provide the data sets and help assist with getting that information to Dr. Cravens. And I guess in my mind, the idealized approach would be to look at actual charges, actual bonds set at the beginning. And ideally you would endeavor, and I know this would be a tremendous amount of work, you would try to identify cases that are as nearly identical in charge and factual circumstances as possible. And that would be a massive undertaking. But if you could do that, and then start the analysis with what are the different bonds that were set in those very similar cases, I think that would be that sort of the ideal to work towards. And
I don't want to take up more time than we have. I just want to make sure I'm wrapping my mind around what you're saying, Judge. Are you proposing actually sort of the way you would argue is that it needs to be sort of like a case study itself, like actually looking at, and I guess I'm wondering, is the information there that exists to do the comparisons that you're talking about?
So I
And-
don't know if I know the definition of case study, but yes, it would, to the extent that, is it possible if you have enough resources and time and energy to do it, you could start a classification process of, let's just use domestic battery. You know, what were the general underlying allegations, type of harm, nature of the relationship between the parties, because there's all sorts of domestic relationships. And then what charge flowed from those allegations. And then you did a comparison of the bonds set in those very similarly situated cases. Then you would be able to start to pick out, if there are material differences, can we control and can we understand what those differences are? And that is, again, I know the work that went into this, and I think it can answer some questions, but to me, this doesn't present insight into where your question started, which was the judicial portion of the overall justice question. Does that make sense? And that's really the only thing I want the council to understand is this is useful information. I don't want it to be interpreted as putting a lot of insight into what the judicial decision-making process is. I guess I will say, you know, I offered that information. I know Judge Simpson has met several times, and I feel bad that I didn't do more to start the process of getting information. Dr. Cravens we met yesterday via Zoom. He's told me he's willing to go through that to the extent we can get valid information, and we're going to do that because I want to know if that decision-making process does have these same things that would be a concern for us.
Judge McCabery, I just want to say, the social scientist in me is very excited. I always love the idea of more data, and having two different sets of data to compare, I think only can give us a more robust understanding of what's happening within our local criminal justice system. I do wonder, Darren, if your question may be a little bit different, because it sounds to me like a big part of what we're looking at in today's data and in future data is the question, are we treating similar cases similarly? And that helps us understand the racialized component of what's happening, which is fundamental to what we do as a system. But it sounded, Darren, like you were also asking a more values-laden question of what is the role of bond in our system? And do we have goals for how we use OR bonds, cash bonds, surety bonds, separate from the race question of when we use these tools, are we using them similarly? It sounded like your question may have been, how should we be using these tools at all? I don't want to put words in your mouth.
Go ahead, shove them in there. No, excuse me. I think that is absolutely, that is a much better expression of what I was trying to like pull out of my head. Apologies, y'all. 90 minutes of sleep right now, and I think it's really, and I think Tamara, for her question as well, because that actually did help me figure out some of this distinction right there. Because I think my impression is that we can't pull apart the question of equity without knowing, okay, what are we, what's funnel, and what makes the most sense. Anyhow, yes. Short version is yes. Thank you. Cosign.
I have another question that I don't know if it's getting at the same things that you've been talking about, but I wondered, as I look at the graph of unadjusted median district court cash and surety bond amounts, how much have you been able to drill down on the largest or the most problematic area of Black individuals and see what percentage of those 1,299 individuals are getting cash surety bonds and some other kind of a bond? I mean, and what percentage of them, and what did their cases involve? And maybe I'm saying something that's similar to what you've already said. I guess I'm asking to be able to drill down more on the individual cases in that 2,000 number. What's going on there?
Right, that's a good question. And I think part of your question, I know you're asking also about drilling down individually on specific cases, but I think it also seems like part of your question is trying to determine how does race influence the type of bond that you get? So not just the bond amount, but is there a difference in how Black defendants are given cash as opposed to own recognizance or something like that? And I did initially do some analysis of that, and I didn't present any of the results here, but that's something we can do in the future. I didn't find as many racial differences there. It was modest, but there are some, and that's something we can present in the future.
Well, I guess I just wonder, is there a large percentage of the Black population on that particular graph that are qualifying for a higher price bond, cash bond? I mean, is their history such that they would qualify more for a higher bond?
I want to interject here because I think that that's part of the confusion that I'm hearing from everybody's question is what we're looking at in the charts is the data when they are booked into the jail. So those bond amounts are not going to be necessarily set by a judge unless there's an outstanding warrant and there's a bond amount associated with the warrant. When we start talking about later decisions that the court is making about criminal history and whether or not to modify the bond, that's not contained in the data set that we're looking at. I think that's what's causing some of the confusion. So if you are arrested and you're not arrested on an outstanding warrant, then your bond, if you will, at this stage that's contained in this data is based essentially on what you've been charged with. And that information does not necessarily mean what the district attorney's office is ultimately going to charge you with, or what you're going to be facing when you meet with the judge for first appearances. It's going to be more so based on what the officer is arresting you for. So if the officer has chosen to place you is chosen to find probable cause to arrest you for a felony versus a misdemeanor, that is what's determining what this bond amount is that we're talking about, unless there's an outstanding warrant where the district court has already set the bond amount.
And I think this may go back to the question we were asking about the numbers of Black individuals who were charged with aggravated charges.
Right.
I mean, why are so many charged with aggravated crimes? Is it because they have had a verbal conflict with the arresting officer? Is this some prior knowledge? Is this some sort of vendetta on the part of the arresting officer? I mean, we haven't, to my satisfaction, we have not answered that question.
And sorry, well, just one quick clarification I want to make is that the bond information on the dashboard and that I've been analyzing is the bond information after it may or may not have been amended. It's at release. So if there was an initial bond set at booking, that bond could have gotten changed, and this is the changed amount. So this is the last updated bond amount in the system. Sorry, that's all I wanted to say.
Yeah.
Which I don't want to speak over anybody, but that bond figure, I don't understand its correlation to what we're analyzing on the front end. To me, that's again, it's for analytical purposes for a variety of reasons, but analyzing that decision-making process, those bond amounts can go a lot of different directions between the time the case starts and the time the case resolves.
I just want to throw in that using the case domestic violence, for example, that Judge McCabery brought up, in terms of even a simple case, well, I don't want to say it's simple because it's always very complicated, obviously, and it can be very, very destructive. But even with a domestic violence situation, we still look at criminal history, right, for purposes of the bond, and we also look at lethality. So if you have there's a domestic violence situation, there's a domestic violence situation. So you could have a domestic violence case that comes for charging where the intimate partners, for example, are, maybe have yelled at each other and maybe something's been thrown across the room. That's bad. But what if you have a situation where the intimate partner has sought to choke the individual, and that's considered aggravated because of the chance for lethality. If you then take that, look at the defendant or the suspect, and you go and you look at their criminal history and you see escalations of lethality, potential lethality, that's also a consideration. Is that person potentially violent, that this person, if they're released, can go and harm the victim? So this gets to victimness and victim-centeredness. So even drilling down to what, Judge McCabery talked about a few of these factors, it's not just taking a domestic violence case and comparing it to another domestic violence case. That every case speaks for its own. There's all sorts of variables that go into how these cases are looked at and the bond amounts that are required or asked for and requested in front of the judge. And I'm glad for Shay's clarification here, because that was something else that I wanted to jump in on. Just looking at the type of case it's going to give us information, but in order for it to be meaningful, it's very, very complicated. It's very, very complicated, and to drill down and compare one case to another in a category, for example, domestic violence doesn't explain what goes into the request, or when the judge is finally deciding whether to grant an OR bond or lower or a cash bond, or even pretrial services, a recommendation. I mean, we've gotten recommendations from pretrial services that look, but we know more about the case. We know more about what we've seen. And so we may reject it because, and ask for a cash bond because lethality is of the victim is high, possibility is high. So we need to keep that person in jail. The other thing I want to say is that bond modifications happen all the time. We've been doing a really good job at looking, and once the case has been moving along, right, and we realize that the individual who is in, we see Matt's and Mike's reports every Friday. We do what we can to figure out, all right, is it possible for a modification of the bond now that things have passed? We know a little bit more about the case. We've done a little bit more of the drill down on the defendant, on the victim, on the factual basis. Can we have the bond modified? Absolutely, and we encourage it. So we're trying to do, but that's up to the defense at this point, right? To file those motions to modify bond, but we bring them in front of judges all the time.
And you're speaking, excuse me, but you're speaking to what you're doing now. And this data is from 2016 to 2020. And so I guess I am wondering, do we need to be looking at what the bond is at charging and what the bond is that the court decides? Do we in these cases, and to see if there is a difference?
I guess what I was trying to do, and maybe I went on a roundabout way here, is that there's so many variables that go into this. I'm not sure we're going to get clear answers to. I don't know. I'm just saying it's fairly complicated. It's not as simple that, in ways that we may perceive it to be a simple thing. It isn't. It's very holistic. At least that's how I've seen it. Whether that's happened in the past, I don't know. I'm just offering my observations.
I think that what we have seen clearly, if I can, Tamara, and if I'm not saying this correctly, please correct me, is we have seen that there is a difference in the race issues in terms of whether an officer chooses to arrest or issue some other sort of citation to return and the number of charges. And I think since we have identified that as a potential place to start, it's now being correlated in some ways to bonds, and maybe that's where it's gone off track. But the point is, if we know that that is a point of discretion that is resulting in some disparity, that may be a place to start the discussion. And I think that has worked its way out in terms of this conversation when we're talking about bonds, but I think we're all saying the same thing, which is this a problem? If it is, what if anything can be done to address it? And one of the things that we had identified, I think early on in this group, is trying to look at bonds just to see if that was another point of issue, if that is where the problem was. But it sounds like, at least right now, what we can say is that there's an issue before that. And that's something we can look at.
I think that's a really important point, that we know that there may be systemic issues at that initial contact between the community and policing. And what we're seeing in these data is that there may also be patterns that are happening when it comes to bond decisions. And so just because we know that there are patterns of behavior at that initial contact, that doesn't mean there aren't also patterns that we can see around bond decisions. So I want us to be really careful that, again, this isn't an either or situation, that we can see patterns of systemic racism that happen at that initial point of contact. And we may see some patterns that at times grow out of that because of different charging and because of different arrest rates, but also that we may see some of these patterns, not necessarily intentionally, but these patterns still coming up at other points. So we know that cases are all really unique and that lots of cases have lots of very individualized factors, but we may also see these racialized patterns that are happening across cases. And that's what the data show us in point 2. And that's where we need to say, yes, we have to address this at that initial point of contact. We also need to really take a hard look when we see patterns that are happening at every decision point in the criminal justice system. And when we can get better data so we can have a better, more precise understanding of those patterns, even better. But I think that we need to be careful with the either or language or positioning some of the problems just at a single point of contact within the criminal justice system. I do also want us to not lose Darren's question about what is the role of bond overall in our community and what are our goals and values around that. So separate from kind of racial similarities, how do we see bond as a tool, and is it doing what we want it to do? And I don't know if that's definitely not a question for today, because I know we only have 2 minutes left in our meeting, but I think it would be a really important question for this council to consider and kind of think through long term.
Well, one thing we don't want it to do is to victimize people who are already victimized. And so that is what I'm speaking to regarding this particular graph, and the fact that Blacks are consistently higher in terms of the bonds that they are requested. So we don't want that to happen. So I think we can all agree on that. And that seems to be that it should be a goal for us to somehow drill down deeper with our analysis.
This has been some great discussion, and we clearly have things that we can follow up on from the conversation we've had today. Just due to time, I think we're going to table the last item. Sarah, did you want to say something?
Yeah, Pam, I just think before we leave this, could we kind of summarize what we're going to follow up on, just so the group is aware of what our next steps in terms of this data set are? Someone who's been taking better notes than I have.
Well, I think one thing is I'm going to follow up with the full court data people to try to do an additional analysis that gets a little bit more detail on the types of offenses at the charging decision and some more of the nuances of the data that we've discussed today. So Ted Sandstrom is the data person at the district court, and I've already been in touch with them a little bit, and we'll get in touch even more. So that's one step.
And
Thank you, Matt.
I just want to caution the optimism around how much better data we can put together. And Matt will work with Ted. But my understanding is a lot of that data is going to come in the form of a printed narrative, which would require by hand each case, picking out half a dozen data points, put it on a spreadsheet, and it could take months or longer to do that on such a large sample size. So until we really sit down and go over that data, I just want to temper expectations around that. Know that Matt and Ted are as good as it gets, and you know, they'll follow up with us on what they can and can't do.
So I guess I also heard conversation around, do we need a deeper conversation about the role of bond? And is that happen at CJCC level, or should we do that in a work group first to sort of prepare those comments to bring back to this group? I'm not sure, Matt, Mike, which group would be, if there is a group that would be positioned for it, or if that's just a more general presentation. I think that's something you can take back and decide how best to bring forward that conversation on the role of bond. Just
Sounds like,
some of it might just be educational, just informational to start.
it sounds like something we would have and should be talking about in the racial disparities group.
The purpose, and then what was the intent of them? Yeah. Are we getting what we were intending from it? I think it'd also be helpful to understand what some of the laws in Kansas are around bonds. Because I know there's some limitations probably that we're not even aware of.
Would that work group have time in their schedule to kind of have a dress rehearsal of that conversation and identify some issues that might be of interest to the whole council?
My thought is that work group doesn't necessarily have the representation of experts. You know, the district attorney's office, we do have a defense counselor in the form of Shay. We don't have a judge on that work group. And those are kind of the key people that we need engaged in that. So whether we look for to get representation from those partners on that work group, or we make this its own work group, I need to.
It may not need a
Maybe
work group. I guess it may not need a work group. If it's something that can be just prepared for CJCC, I think we could have that. I just wanted to verify that there wasn't an already sort of established work group for it. It sounds like there isn't, Mike, so maybe it's something offline we can prepare a presentation for in an upcoming agenda.
Mm-hmm.
And it sounds like we need to be patient with the data analysis.
Yes.
Timeline.
Yes.
I know that's not your favorite, Tamara.
No, it isn't, but it's what I'm concerned about is that it happens.
Yeah, agreed.
Do we have any public comment, Mike?
I don't see anyone raising their hand or requesting that. So it looks like we do not have any public comment, Pam.
Does anybody else have anything that they want to add or ask for the good of the order? Seeing none, we're going to adjourn for today. Thank you, everyone, for attending.